a statute to prohibit racial profiling, you would say no official may consider race, color, or national origin in implementing the statute. And Arizona could pass that statute. But they went on and said, except to the extent permitted by the United States or Arizona Constitution. Because my time is short, I cannot go into the cases on reasonable suspicion. They are mostly old. The Supreme Court said in dictum in a 75 case that racial appearance might, under various factual circumstances, create reasonable suspicion of requiring a reasonable stop of a car looking for undocumented immigration. But by itself, it couldn't. The case involved a federal immigration official who was foolish enough to say on stand the only reason he stopped the car near San Clemente, California, was the people didn't look Mexican. And the Supreme Court, writing to Justice Powell, quashed that search and said that was an illegal search. That wasn't reasonable suspicion. Reasonable suspicion requires articulable facts, wrote Justice Powell. My word processing program is telling me that articulable is not an English word, but it's what Justice Powell said, so who everybody said since. And they listed a bunch of factors that might constitute reasonable suspicion. More recently, the Ninth Circuit, which covers Arizona, had a case involving a vehicle stop in Imperial County, California, the southeastern corner of the state, right smack against the Mexican border. And they said that in Imperial County, California, Mexican appearance can never be relevant to a stop. The population of Imperial County, California is 73% Mexican ethnically. The U.S. citizens look Mexican. The lawful permanent residents are Mexican. They're Mexican nationals lawfully working in the United States on green card or other temporary worker permits. And, of course, the undocumented migrants are also Mexican in Imperial County. So the Ninth Circuit opined in dicta, it wasn't necessarily the case, that as they saw it in Imperial County, California, looking Mexican had no value whatever in deciding reasonable suspicion. So that's where we're at constitutionally, and it's rather, it's a little difficult to say which parts. Undoubtedly, there are parts of Arizona that are rather like Imperial County, where the courts would hold that Mexican appearance wasn't even a factor in reasonable suspicion, and others where they would hold that it might be. All right. The other aspect of 1070 that's important to understand are the 4 new Arizona crimes, none of which is a federal crime. 1070 makes it a crime. 13509. Whoops. Okay. Makes it a state crime willfully to fail to carry alien identification. The district court enjoined enforcement of this. Makes it a crime to transport a non-citizen who's not in status in immigration if the person transporting is doing it for gain and had reason to know the individual's lack of immigration status. The district court is not giving a lift to someone who's undocumented. The district court has not ruled on that one. A third new Arizona crime is stopping your car to pick up someone looking for work. The district court has not yet ruled on this section, and where you're blocking traffic, sorry. And then the fourth new Arizona crime is for a non-citizen not documented to do so to work, to apply for work. That, the district court enjoined enforcement of that. These do not simply repeat federal crimes, as is often asserted. None of these is a federal crime. Obviously, there's no federal law on stopping your vehicle or giving a lift to an individual. Federal law has a very limited set of sanctions against employers who hire undocumented workers, but it is not a crime for the worker himself to work while they have immigration status. And finally, the Alien Registration Act of 1940, the same statute under which Japanese citizens were put into concentration camps, we'll hear about this in a second. It's still on the books. It does have a provision requiring non-citizens to carry at all times any certificate of alien registration or alien registration receipt card issued to him pursuant to this section. I have my grandfather's alien registration card up in my office, but and that's a federal misdemeanor. But that's a dead letter on the federal statute because the federal government no longer issues such certificates. They issue completely different immigration certificates to prove immigration, and that failure to carry them is not currently a federal crime. All right, we could go on. We've now seen enough of SB 1070 to understand why it's not something, I will argue, that a state, as opposed to the federal government, can adopt. It very closely resembles 2 earlier state schemes requiring non-citizens to submit to state status checks, both of which were held unconstitutional. These precedents do not turn on little details concerning the earlier scheme. They turn instead on broad constitutional principles as to which powers the Constitution gives to the federal government and the states. basically setting enforcement priorities must reflect the needs, including the diplomatic needs of the whole country. A state with its own immigration policy could create diplomatic issues that would harm the whole country, not that state. The two directly controlling precedents, in my view, are an 1875 case called Chi Lung against Freeman and a 1941 case called Hyde versus Davidowitz. Judge Bolton placed most of her reliance on Davidowitz, but I want to say just a word about each. Chi Lung against Freeman first, 1875. California in the 1870s saw enormous agitation over immigration from China. In 1875, California adopted a plan to require state officials to inspect arriving aliens and condition their admission on posting a bond if they were deaf, dumb, blind, crippled, infirm, lunatic, idiot, pauper, convicted criminal, or lewd or debauched women. The Supreme Court unanimously held that California could not adopt such legislation under the federal Constitution. The importance of Chi Lung is it does not rest on Congress's occupying the field. In 1875, there wasn't any federal immigration legislation. In the years to come, the federal government would adopt legislation restricting new immigration from China, and the court would eventually uphold that legislation. So Chi Lung doesn't rest on statutory preemption occupying the field. It says there are things states cannot do. And why can't they do that? The court said because it poses a danger to the diplomatic policies of the United States. The court hypothesized a California decision to require a bond of a citizen of Britain. Here's the court. Can anyone doubt that this matter would have been the subject of international inquiry if not a direct claim for redress? Upon whom would such a claim be made? Not upon the state of California, for by our Constitution, she can hold no exterior relations with other nations. It would be made upon the government of the United States. The passage of laws which concern the admission of citizens and subjects of foreign nations to our shores belongs to Congress and not the state. If it be otherwise, a single state can, at her pleasure, embroil us in disastrous quarrels with other nations. Okay, so there's Chi Lung. It's not a statutory preemption case, and it doesn't rest on any great love of Chinese people because they would soon be subject to very harsh federal laws which the court would uphold. Here's my point. History reinforces the court's concern in Chi Lung. These were not theoretical. Despite Chi Lung, California continued to use state law to discourage migration from Asia, at a real cost to American interests. China was a weak country then, unable to retaliate, but Japan was another story. After the Japanese military victory over Russia in 1905, President Theodore Roosevelt, who mediated the end of that dispute, was very impressed with the Japanese and wanted to pursue alliance with Japan as a major element of U.S. foreign policy. He was frustrated by what he called, in an unguarded letter, the idiots of the California legislature who were busy segregating Asian from non-Asian students in the public schools. Roosevelt was irritated that his meetings with the Japanese ambassador didn't include what he wanted to talk about, which was a big alliance between the U.S. and Japan. They concerned the ambassador's protests over the treatment of Japanese nationals by American state and local governments. He wrote to Roosevelt, to his son Kermit, "I'm being horribly bothered by the Japanese business. The infernal fools in California, especially in California, insult the Japanese recklessly, and in the event of war, it will be the nation as a whole which will pay the consequences." I'll skip the later history of relations. Of course, we cannot know what the history of U.S.-Japan relations would have been without this legislation, but the leading historian of these events believes very strongly that the California legislation frustrated friendship between the countries, which both national governments actually wanted, and led directly to Japan's alliance with the Axis in World War II. All right. The Supreme Court reinforced this point in 1941 in Hyde versus Davidowitz. With war looming, many states rushed to require registration of their alien populations. When the Davidowitz litigation began, the federal government had no such scheme. But by the time the case reached the Supreme Court, Congress had enacted its own alien registration scheme. Pennsylvania's scheme, which was very close to Arizona's. Pennsylvania defended its just as Arizona defended its, by arguing that it was merely providing more effective enforcement of the same underlying federal policy. Both required aliens to register. But Pennsylvania had some extra twists. What were the extra twists? The non-citizens had to carry their registration with them, and it was a crime not to carry it or show it on demand to local police. It was the Arizona scheme. That's why I think this is not a close case. Right? The federal law passed in 1941 just said it's a crime for an alien not to register. Pennsylvania went further and said it's a crime not to carry a registration and not to show it to the police when they demand it. And Pennsylvania said it's the same policy, we're just providing more effective enforcement. The court struck it down. Right? They noted the supremacy of national power in foreign affairs, the important and delicate issues of protecting another country's nationals when they're in our country. Legal imposition of distinct, unusual, and extraordinary burdens and obligations upon aliens, is a quote, such as subjecting them alone, though perfectly law-abiding, to indiscriminate and repeated interception and interrogation by public officials, thus bears an inseparable relationship to the welfare and tranquility of all the states, not merely the welfare and tranquility of one. Any concurrent state power that may exist, this is foreign affairs, they said, any concurrent state power is restricted to the narrowest of limits. It is of importance, wrote the court in Davidowitz, this legislation deals with the rights, liberties, and personal freedoms of human beings, is an entirely different category from state tax statutes or state pure food laws. Pennsylvania defended its statute exactly as Arizona defends it, a permissible way of enforcing federal law more directly. Under the Supreme Court standard, neither Pennsylvania nor Arizona is free to make this decision. Congress had, the court noted, consistently refused to adopt a registration scheme with photo identification that would have to be shown to police. Opposition to these bills was based upon charges that their requirements were at war with the fundamental principles of our free government and that they would bring about unnecessary and irritating restrictions upon personal liberties of the individual and would subject aliens, all aliens now, to a system of indiscriminate questioning similar to the espionage systems existing in other lands. In other words, the congressional scheme, crime not to register, was not a floor that the states could exceed. That was the whole story. That was the final word, because it was Congress's decision under its foreign affairs powers about how to treat foreign nationals. When Congress created alien registration, this is crucial, it plainly manifested a purpose, this quote, to do so in such a way as to protect the personal liberties of law-abiding aliens through one uniform national registration system, and to leave them free from the possibility of inquisitorial practices and police surveillance that might not only affect our international relations, but might also generate the very disloyalty which the law is intended guarding against. Okay. So, as I read the case, as I say, there are difficult preemption issues, but this isn't one of them. Everything that's interesting about the Arizona statute required status checks, required IDs, required status checks by the cops, crime of not carrying it, crime of not showing it. It was been there before. It's been before the Supreme Court. It's not something states can do, not for narrow and technical reasons, but because it's important to have national uniform policies here. All right, I'm out of time, so I won't discuss the liberties claims, just the preemption claim. I just want to end with one historical epilogue. I will keep my promise not to discuss the policy aspects of the Arizona scheme. So you can decide that for yourself. I'm content if I've shown you that whatever you think the immigration policy should be, it must be something that Congress does. It's not something that states can do. But I do think that these two cases provoke a historical reflection. The California law of 1875, the Pennsylvania law of 1939 were unconstitutional, but they were also deeply stupid. Each reflected a hysteria at the time, an anxiety brought on by economic depression and menacing foreign relations that led otherwise normal people to identify their problem from immigrants from China or from the rest of the world. With hindsight, we can see how misplaced these fears were. Nothing bad happened after these laws were struck down. The federal government continued to enforce immigration, albeit at a slightly lower key than California and Pennsylvania. Neither Chinese immigrants in 1875 nor resident migrants in 1939 ended up posing the slightest economic or national security threat to the United States. Their descendants and they themselves fought and died for the United States in the war that was looming as Hyde versus Davidowitz was decided. Many of you in this room are the descendants of those very aliens who seemed so frightening in 1875 and 1939, as I myself am, and it is the genius of America today that you are as American as any one of those people who purported to judge your grandparents. We are living in an era of similar economic stagnation and fear, and a federal system that needs reform in 100 ways. I'd be happy to discuss with the Federalists at any time. Some we agree on, some we disagree on. The United States and Mexico will share a border so long as both countries exist on Earth. The only American strategic interest in Mexico that I can see is that it develop as a peaceful, stable country with a large middle class and a big appetite for American products. Now we can, if we choose, use immigration law to make enemies. We can do that. We've done it before. We did it in Japan. Or we can use our immigration law to build cooperative solutions to the joint problems that face the United States and Mexico. That's a political choice, and each of you will have to decide what that political choice would be. But I'm just here to say that political choice is a national political choice. It has to be made nationally in the foreign policy interest of the nation. It is not something that a state can make for itself. Thank you.
Thank you, Professor Hyde.